Welcome to the Unlocking the Club podcast, where we host honest and direct conversations about journeys of access, personal truth, and reclaiming space. We share our truth so that you can find the key to own your truth, honor your journey, and reclaim your space. Grab your keys, your wallet, your phone, and invite your friends to meet you at the club. Here's your host, Angela Taylor.
Welcome to a very, very special series of Unlocking the Club, where we explore one of the most important yet often overlooked conversations that we can have, a conversation about estate planning and elder care. I'm your host, Angela Taylor, and over the past few years, my family, my friends, we've learned the hard way about the critical importance of having a will or a trust in place. When unexpected moments arise, not having a plan can leave families vulnerable. And I've seen firsthand how it can create chaos during already challenging times. Recently, I conducted a poll and the results were startling. 80% of the people that I polled between the ages of 20 and 65 don't have a will or a trust in place. Even more striking is that most of those who do take action, it's only after experiencing a tragic event in their family. National data suggests and supports this as well, with studies showing that a significant majority of adults, particularly between and within the Black and BIPOC communities, have not taken steps to secure their legacies. And when we fail to plan, we leave our families with legal battles, financial burdens, and emotional stress that can take years to untangle. That's why here at Unlocking the Club, we're dedicating an entire 12-part series to unlocking the essentials of estate planning, with bonus episodes focused on adjacent topics. Together with two brilliant minds, Shane Jasmine Young from Young Law Group and Verlena Green-Tuluska from VDG Law Group, we'll break down what you need to know about protecting your assets, building a legacy, and making sure your loved ones are cared for when it matters the most. Our goal in this series is to equip you with the knowledge and the tools to take action now before life forces you to. Whether you're just starting out or navigating the complexities of caring for aging loved ones, these conversations will give you the clarity and the confidence to plan for your future. So grab your notebooks, tune in, and let's unlock this critical conversation together. Welcome to Unlocking the Club's special series on estate planning and elder care. Welcome back to Unlocking the Club. I'm your host, Angela Taylor, and we are here for our 12-part series on estate planning and elder care. Today, we're going to talk about guardianships and conservatorships. Guardianships and conservatorships are legal tools that are used to protect those who are unable to care for themselves, whether that is due to age, disability, or incapacity. Today, we'll discuss where these tools are necessary and what families should consider when setting them up. Joining us today to discuss guardianship and conservatorships is Shane Jasmine Young of Young Law Group. Shane, thanks for joining us.
Hi, Angela. Thanks so much for having me.
So good to be in this conversation with you. And now just a topic that for me has come up recently, probably because of some celebrities. And you started to hear this terminology, but what's the difference between guardianships or conservatorships, and where might each be necessary for families who are considering estate planning?
So they typically can be interchangeable, and depending on where you're located, depending on which state you live in, the different states might have different terms. So in Nevada, for example, we typically refer to it as a guardianship. And it comes into play in most cases when, we have an elderly person or someone that has, disabilities that make it difficult for them to be able to care for themselves or make their own decisions, and they need someone else to legally have authority to be able to handle, medical decisions, their financial affairs, pretty much any type of legal affair that they would need. They need someone else to be able to kind of step in.
Okay, that makes sense. So interchangeable, and really for all of you listening is to find out in your state what some of the terminology may be, or with the attorneys that you're working with on your estate planning. Shane, so when you think about these two things, let's just call them guardianships, like how is a guardian appointed, and are there specific legal steps that are involved in that process?
Yeah, so it's going to look different depending on what type of planning or lack of planning, if there's nothing in place. So if there's no legal documentation in place ahead of time, then a family member or someone on your behalf has to petition a judge to be able to step in and be appointed as your guardian. And that happened, you might have seen in certain celebrity cases like Britney Spears, where her dad stepped in and was appointed as her conservator or guardian because she was found to lack the mental capacity to be able to make certain decisions on her own. So that's what happens in, that type of scenario where you have to basically go through the court system, go through the court process. Now, if you have your estate plan set up ahead of time, where, for example, if Britney Spears had an estate plan and said, you know what, if I do become incapacitated in some way, if I'm not in a position to make my own decisions, then I would want this person, that person, and then, whoever she would want on the list, then it would have been her choice as far as who would have stepped in on her behalf. So that's where planning ahead really has additional benefits, right? You're planning, you're thinking of, what could happen in different circumstances, different contingencies, because, while we're alive and well, we may not be thinking about, what happens if we have a mental breakdown, or if we have some type of disability that, makes making decisions, even taking care of ourselves on a day-to-day basis, difficult. So planning ahead where you are able to essentially appoint people to step in if you do become incapacitated, if you're disabled, if you can't handle your own affairs. It's a lot easier of a process to, transition into that because you don't have to go to court. So it's a huge benefit, of planning ahead versus not.
Yeah, well, and one of the things that is ringing true for me throughout our conversation about estate planning is start planning now, start having these conversations now. So when we think about guardianship, how can you be proactive? When is it appropriate for someone to consider either seeking a guardianship for a family member or for themselves? Or how can you, if you are planning well ahead of when you anticipate you may need something, how can you start to sprinkle that into a planning conversation with your family or your loved ones?
It's much more difficult to do it after the fact, right? Because you have to go through a much more arduous process, have to go through the court system, have to petition a judge. So that's what happens, as we discussed a few moments ago, when you aren't proactive or you're not planning ahead. And then now you're in a situation where, oh gosh, well, now I've got to step in and take care of, this family member who can't take care of himself or herself. So it can be really stressful when you're already dealing with, the normal life stresses of having to care for a family member. So on the other side of things, it's much better to put an estate plan in place that includes powers of attorney, guardianship provisions, disability provisions, so that no matter what type of contingency happens in the future, you already have it laid out as far as who can step in, when can they step in, what types of decisions can they make, what are the wishes that you have, would you want to be kept in your own home, or would you want, whatever those specific wishes are, you're able to lay all of that out within your estate plan, within a proper estate plan, I should say. So it's never too early to be thinking about these things and to actually take action. Many times we get so busy and we're focused on, different things. We've got different priorities. Our day-to-day lives can be very hectic. We're working, and handling all of the the normal day-to-day activities, and we don't have the opportunity, or we don't make the time to put these things in place, because it's not, it's typically not a fun thing to think about, right? So, in one of our earlier segments, when we talked about, some of the common misconceptions, one of the things is most people just don't realize that we all need an estate plan. Once we're 18 and we are legal adults, we need to have an estate plan in place that appoints the right people to step in the event that something happens to us. Because when we don't have these contingencies planned for, we leave it to the courts and to a judge to decide. So really, at any point, once we become legal adults, these are things that we should be thinking about, and we should be taking action on, because things happen, accidents happen. And even though we hope that things won't change, our lives drastically until we're much older and we've lived a full life, things happen. And so it's much better to be prepared and do things while we are alive and well, and we can make these decisions and get peace of mind knowing that if and when anything happens, all of these items will be taken care of.
Yeah, peace of mind is one of the primary reasons that this is so important. And Shane, I'm glad you actually mentioned Britney Spears, because that was the celebrity that was top of mind. And unfortunately, because of the news of her situation, for me, there was a negative connotation associated with guardianships or conservatorship. So I guess a couple questions. One, like, what are the responsibilities for a guardian? And then are there any alternatives to guardianship or conservatorship that families can consider as well?
So the role or the responsibilities that come along with guardianship, it's going to depend on, it's kind of a case by case thing. And also, if you are planning ahead for it, your estate plan can identify and provide, certain provisions that would say, in the event that, this or that happens, if I become incapacitated, then my guardian can step in. And, we've got like a list of duties or responsibilities of, kind of what their authority or how far their authority extends. So another reason why it's important to plan ahead is you can be proactive in saying, here's what they can do, here's what they can't do. You're basically designing it and providing that legal authority. If not, like with Britney Spears, and you have to go through the court system, it's a judge that's making those decisions. And, typically it's going to be based on what the judge's assessment of that person's abilities are. So if, in her case, I don't know all of the facts, but I know that quite a few major life decisions were taken from her, as far as like whether she could have another child. She definitely was not able to manage her own finances. And, so these are really important decisions, and what would be involved in that authority really would be left in that case. It would be left to a judge to decide, and how long. So that guardianship with Britney Spears was in place for several years, and she kept having to, she was trying to be free of the guardianship, and she had to go through many years and legal battles over that one decision. And then, she ultimately was granted, her right to make those decisions for herself again, as we saw.
Yeah, living out like right in front of us, reality TV, unfortunately. And I imagine for many normal individuals, right, it's not playing out in front of everybody, but there's a lot of complications and complexities to this. And the thing that keeps showing up for me is the financial implications. So, if you are serving as a guardian, like, what are some of the financial implications you should consider, or are there any safeguards that the party should try to put in place to prevent that financial abuse or any other sort of abuse?
Well, when you are appointed as a guardian or conservator, you have a fiduciary responsibility, which means that you have to act in the best interests of, that incapacitated person. So if you do, steal, or you embezzle, or you're not utilizing the money or the assets, you're doing things in bad faith. You actually you're liable. You can be sued, you can be taken to court. There are different penalties and consequences that you can face for those types of actions or misconduct. So it really carries an extremely important responsibility and burden to make sure that you're acting in the best interests of that person who you're acting or caring for, appointed to care for. You brought up another good point, actually, in one of your previous comments, where with Britney Spears, for example, like this was something that was public. So if you're looking to keep these matters private, that's why we do planning. You want to do your planning ahead of time, because those matters are private. Those do not go in front of a judge. They don't become public record. It doesn't become part of a news story, because these are things that have been identified and planned for and laid out specifically, or should be laid out very specifically within your estate planning documents, so that everything can be handled privately without the public or anyone else being able to see into it.
Yeah. Well, and I'm imagining a lot of our listeners or viewers may be thinking this, like, it feels like a lot of steps, right? You have the power of attorney, advance directive, if you need guardianship. And if you find a capable expert attorney to work with, all of this is part of the process, right? And it doesn't feel as heavy or weighty.
Right. And that's really what our job is, to make sure that we are looking at all of the details and all of the provisions that need to be addressed within your plan, so that we can empower you, we can educate you to be able to make, the decisions that you're comfortable with and that really work best for you and your family. So, you really make a great point, because it can seem overwhelming when we start talking about, like, oh my gosh, all of these decisions. But when you're working with a good, thoughtful, comprehensive estate planning attorney, preferably, then these are things that we do day in and day out. And, we know how to navigate some things that can seem very overwhelming or complicated, to, a normal person who doesn't live estate planning every day. And so that's really the value that we bring, is being able to cover all of these bases and make sure that you have peace of mind, but you're empowered to make the decisions that actually will work best for you.
Yeah, and that's why I think your offer for a free consultation is quite remarkable. If you're trying to do this on your own and you're doing Google searches and trying to piecemeal together all the things that you need to do, first, the fact that you're doing something, kudos to you. And here's a great resource with an expert, as you've been listening to over the course of the last couple of weeks, and Shane, that does this in her sleep and knows exactly what questions to ask, so you have more clarity over what some of the things that you and your family should consider making sure that are part of your estate planning process.
Yes, and I do encourage everyone that's listening or watching to take advantage of the complimentary planning session. There's so many things that we just don't think about, and you just don't know what you don't know until you're able to actually have conversations and ask questions, and for us to ask you questions to really determine what are your goals, what are the priorities that you have, what are the family dynamics, because it varies, from client to client, from family to family, and we want to make sure that it's not a cookie cutter, type of process or a one size fits all set of documents. We want to make sure that the things that are important to you are properly identified and properly planned for within your proper comprehensive estate plan.
So in your estimates, like, how frequent do you have guardianship or conservatorship part of an estate plan? Is that a rare occurrence, or is it something that actually happens more than we would imagine?
Well, it's actually just implied, within the
Okay.
documents that we prepare. So what we'll do when we go through the planning process is we'll ask, okay, so if you do become incapacitated, what are the decisions that you would want to be made in certain circumstances? Like, would you want to be on life support indefinitely, or would you, want, this procedure, or would you want life prolonging, measures taken even after there's no brain activity? So there's all these different questions and considerations as far as what decisions you would want made in certain instances or circumstances, and then who you would want stepping in to make those decisions for you. Who can talk to your doctors, who can get access to your medical records, who can make your medical or end of life decisions. So we talk through what those items are, who those people would be, and then we're able to draft in those provisions so that if you were incapacitated, it's really like the power of attorney that steps in, kind of in that guardian role.
So now as we are navigating our way through these 12 episodes, I'm getting a picture. It's a puzzle, right?
Mhm.
So estate planning is literally putting all of these tiny puzzle pieces together, and there's a lot of correlation and connection between different things that are taking place. And again, something that feels vast and complicated for someone that does it on a regular basis isn't so much.
Mhm.
As well. Well, when we talk about or think about guardianship or conservatorship, is there anything else that our listeners or viewers should consider or should know?
I would just encourage everyone again to really take advantage of the resources that are available. If you're listening or you're watching if you're listening to the podcast or watching the podcast, you already have the advantage because most people don't even have access to the information or they're not seeking it out. So just the fact that we're sharing this information, and again, Angela, thank you, for utilizing your platform to provide this information. It's so, so important that we get this out there. So really just encouraging everyone to take in the information, utilize the resources, schedule that complimentary session. And, you may not even think like, well, I don't even know what questions to ask. Don't worry. I have all the questions that we need to cover. And then even if you don't think of the questions until afterwards, I always tell clients, it's okay if you don't, if you didn't ask all your questions now. It's an ongoing process. So whenever you have a question, just reach out. And that's another thing that's important, is having that relationship, that ongoing relationship where it's not a one and done, transactional type of situation. We want to be there as things change, as you have questions, as, the laws change, as your assets change, to be there to support you. So, you want to find that a good match, and you've got the resources available. So I hope that you all will take advantage and utilize them.
Yes, I encourage you all. And so grateful for many of you that have reached out via social media or private messaging to say that you are enjoying the conversation that we've been having with Shane and Verlina. Some really important information that, again, we don't often take the time to pay attention to, but realize that it is tremendously important to making sure that we secure our family's legacy and our future. So Shane, I am grateful for you for continuing this conversation. And in this particular episode around guardianship and conservatorship, providing such clarity over what they are and that they're really part of the process and part of the conversation that you would have with your clients.
Yes, it's my pleasure. Thank you so much.
Absolutely. Well, for another episode in our special series, Unlocking Estate Planning and Elder Care, I'm Angela Taylor. So grateful for Shane Jasmine Young for joining us and talking about guardianships and conservatorships. In the show notes, make sure you scroll down to the bottom. You'll see the special offer from Young Law Group that's offering you a phenomenal opportunity to get a free consultation with an expert attorney that can help you navigate this process. Take her up on the opportunity. And please continue to listen to our episodes. We have some more great content coming as we continue this special 12-part series. Again, for Unlocking the Club, I'm your host, Angela Taylor. Until next time, be well.
Thanks for listening to Unlocking the Club. If this conversation resonated with you, subscribe to our podcast on iTunes or your favorite streaming platform. so that you can experience every episode. And follow us on social media, where you'll hear about future guests, access special features, and connect with this amazing community. Head on over there and let us know how you are unlocking the club. Until next time, peace.